Good morning, everybody. You are aware we have started this web series to bring to the notice of the listeners the most important and the controversial provisions of the Constitution, which were misunderstood, misused, misapplied, as a result of which we are facing political instability, political uncertainty, political immorality, abnormal poverty, conflicts of caste, community, creed, region, religion, language, and sex. There is cross border terrorism and internal extremism. People are committing suicides, not being able to live in this society created by this constitution and the rulers and the system as a whole. Today, I will discuss how it has happened in India. In my opinion, it is the English language which destroyed India. Unfortunately, the constitution is in English, its usage in English rather, and the elite people of this country are treating English knowledge as something, a virtue, which unfortunately most of the Indians do not possess. The language of the courts is English. Of course, originally it was decided that it shall be so for 10 years and afterwards it could be reviewed. Whereas we are continuing the same language yet. We have failed to establish a link language in India. It is not the question of link language. We have failed to create link among Indian states, different sections of the people. As a result, the constitutional objective of fraternity is fragmented. For example, how the constitution was misused, misinterpreted, misunderstood. I will give you only a few examples. In the preamble, it is contained that we, the people of India, having solemnly resolved to constitute India into a sovereign democratic republic. So, people of this country are, on their behalf, the members of the Constituent Assembly, have solemnly resolved to constitute India into a sovereign democratic republic. So, since the people wanted this country to be constituted into a sovereign democratic republic, we should understand that it is the basic structure of the constitution. It is the basic structure of India. Whereas the objectives coming next are and to secure to its people justice, liberty, equality, and then to promote fraternity, unity, and individual dignity. So, justice, liberty, equality are the objectives, fraternity, unity, individual dignity are the ideals. These should not be confused with the basic structure. These are the objectives which we expect to obtain from the basic structure. And the process of constructing this basic structure is democracy. And this process also should not be misunderstood as the basic structure itself, which unfortunately has happened in India. Coming to the phrase sovereign democratic republic, please understand republic is the noun and sovereign and democratic are the adjectives qualifying the noun. Sovereign means a power to make law and to implement the law. This is the sovereign power. So far, even after 75 years, Indian polity, press and judiciary and intelligence of this country are not sure as to where this sovereignty of India lies. Does it lie in the parliament? Rather, does it lie in the legislatures? Does it lie in the executive? Does it lie in the judiciary or elsewhere? Indisputably, it lies with the people of this country. And people of this country have reposed their faith in the legislatures and the executive. So ultimately, it is the parliament which is the sovereign power of this country. When we consider Article 79, parliament includes the president. This is the lawmaking body. The combination of the legislatures and the executive is the lawmaking body and law enforcing authority. But unfortunately, till today, we are not sure where the sovereignty of this country lies. Coming to the next adjective of democracy, sovereign democratic republic. So far, I have no hesitation in saying that Indian polity, press, judiciary and intelligentsia have not understood what is democracy. We are claiming the country to be the largest democracy in the world. In my opinion, India has not been democratic so far. The very fundamental principles of democracy is that there should be separation of powers between the legislative and the executive. Otherwise, it smacks of monarchy. In monarchies, law making, law implementing, and law dispensation. Everything is in the hands of the king. He can impose death penalties on his opponents, he can imprison them, he can exile them. There will be none to question. If anybody questions the king, he will be treated as betrayer, and the king will loot the properties of the other king whom he conquers. His army would create havoc in the country on which they have won. That's what now is happening in India. Whoever comes to power is imprisoning the opponent, looting all state resources, and their workers are creating havoc in the state or in the country. This we can witness in many of the states which I don't want to name, because my purpose is to comment on the constitution. I do not belong to any political party. I have neither favor, fear, or antagonism against any political leader, because they are following the prevalent system without knowing that it is a faulty system. They are victims of circumstances. If they know the true intent of the constitution, sure they won't be against the reform. Why I am saying that there is no separation of powers in India between legislative and the executive is that a person commanding majority in the legislatures is ruling the state and the country. This is not proper. This is only Pakistan model. Somebody becoming chief minister with majority in the assembly, or some other becoming prime minister with majority in the parliament, is contained in Article 91, 95 and 130 of the Pakistan Constitution. Such provisions are not there under Indian Constitution. That is also the reason why in Pakistan only very few prime ministers have survived. Many of them were imprisoned, killed, hanged to death, or blasted through bombs. Or some of them have fled to other countries. Because once you get the majority, you are becoming the king. Your word is becoming law. You are in a position to pass the bills and demanding that the executive must assent to that. This is most unfortunate thing, pure ignorance, abysmal ignorance of the democratic principles. And then coming to the third word, sovereign democratic republic. Republic means a country which is ruled by an elected or nominated president instead of a monarch in which people are supreme. In tune exactly with this design, the constitution has prescribed the election of the president and his rule by the whole constitution is about powers, duties and discretion of the president. The name of prime minister and chief minister would not be found anywhere in the constitution. They are not given even a single authority. They are appointed by the executive and removed at their pleasure. They are assistants, they are servants of the president and the governors. Unfortunately, these servants are ruling the country like a cleaner driving a heavy vehicle while the driver is asleep. That is what is happening in India on political front. Coming to another word which we misunderstood is a secular. During the constitutional debates in the Constituent Assembly, a socialist member, namely K.T. Shah, proposed to add socialist, secular and federal into the constitution, to which Dr. Ambedkar has stoutly opposed, because the constitution is a religion respecting constitution. How can you add secular into that? And what will you achieve? What change will you bring about by adding the word secular when it is already a religion respecting constitution, lending freedom to prosecute any religion and propagate it? So, adding the word of secular into the preamble in 1976 through 42nd Amendment is an illegal activity. You cannot club two conflicting objectives into the preamble of the Constitution, which is the objects clause of this Constitution. Coming to socialism, secular and socialist, these two words were added into the preamble in 1976 through 42nd Constitutional Amendment. Please remember, until 1978, property was a fundamental right under the Indian Constitution. While the property was a fundamental right, how can you say that India is socialist? Of course, that fundamental right, property right, was withdrawn and converted as constitutional right under Article 300A, capital A, in 1978. Coming to federal, this word federal was proposed by K.T. Shah, a socialist, rejected by Dr. Ambedkar, and the Constituent Assembly supported Dr. Ambedkar, despite that Indira Gandhi in 1976 added socialist and secular. How the Honorable Supreme Court could bring the word federal without any constitutional amendment, whether valid or invalid, is a different thing. In S.R. Bommai case of 1994, Honorable Supreme Court held that federal structure of this country should be safeguarded and that elected governments in the states should survive. I just submitted to you, there won't be elected governments. Elected government is only that of the President of India. Others are elected for legislatures. President of India is the only elected executive. So this country is unitary. He appoints union ministers and governors for the states, and governors appoint state ministers. This is the system. If NDA president is elected, there should be NDA governments throughout the country. If UPA or INDI president is elected, INDI governments will be there throughout the country. Then there won't be dispute between state and the state and the center. There won't be midterm elections. The country will be peaceful and prosperous for 5 years. That is the constitutional intent. If we follow it strictly by this time, India would have been richer, more organized than the United States of America. The other English word used in the Constitution, which we have misinterpreted, misused, misapplied, is the word aid and advice. Article 74 says that there shall be council of ministers with Prime Minister as head to aid and advise the President in discharging his functions as President. Of course, Article 75 says that they are appointed by the President and removed at his pleasure. If you refer to Article 53, it says that President of India shall be the executive power of the Union. Executive power of the Union is vested in the President of India, which he may exercise either by himself directly or through officers subordinate to whom. Please understand, he can exercise his executive functions either by himself directly or through officers subordinate to whom. Who are the officers subordinate to whom? The union ministers, the governors, and the whole employees of the union and the states, which are called executive in public service. We misunderstood as the president is bound by the advice of the Council of Ministers. This again is also the condition under Pakistan Constitution of Article 48. Under Article 48 of the Pakistan Constitution, executive power of Pakistan is vested in the President of Pakistan, but he shall exercise such power as per aid and advice of the Council of Ministers, which includes the Prime Minister. Such a condition is not there under Indian Constitution. Yet, since the first president was elected with the support of the then Prime Minister Jawaharlal Nehru, he abdicated his executive power in favor of the Prime Minister and remained aloof in the Rashtrapati Bhavan. Since the same political party and the same family ruled the country for 30 years from 1947 to 1977, it has become practice by precedence. However, they knew the fallacy. It was in 1976, again through 42nd Amendment, which was introduced by Mrs. Indira Gandhi, stated that the President shall act according to aid of the Council of Ministers. The President may return the advice for a maximum of one time for reconsideration of the Council of Ministers. If the same advice is tendered, he is bound by the advice. This is the most unfortunate thing. In fact, the President of India and the ministers should belong to same political party, and the governors and the state ministers also should belong to the same political party. There should not be any conflict at all. Whereas bills are passed by majority political party in the parliament or the assemblies. If the president and governors do not command majority in the legislatures, that is the most ideal democracy as obtaining in the United States of America. The ruler should not have majority, otherwise his word becomes law. It becomes anarchy, not monarchy. How the advice of a subordinate will become order for his master? This is the most unfortunate thing. This is how English has destroyed India. Again, coming to Article 163 relating to the states, there shall be Council of Ministers with Chief Minister as head to aid and advise the governor in discharging his functions. It also says that the ministers shall not be authorized to tender their advices in matters which require the discretion of the governor. So the governor has certain discretions, and Article 154 says that he is the executive power of the state, which he may exercise either by himself directly or through officers subordinate to him. So the advices are not binding. Advices of not only the Council of Ministers, advice of anybody is not binding on anybody. Advice in advice, it is only a suggestion. It can never be a command or order. If Indian people cannot understand difference between an advice and a command, even God cannot save this country. What should happen to Article 60 and 159? Article 60 is the oath of office, and Article 159 is the oath of the governors. These two people take oath to preserve, protect, and defend the Constitution of India and the law, and to devote themselves for the service and well-being of the citizens of India. Is it the way to discharge that lofty oath of office? They are simply sitting in their chambers, either Rashtrapati Bhavan or Raj Bhavan, waiting for instructions in the form of advices to come from the ministers. This is the most unfortunate thing what is happening in India. Is it the way to dedicate their lives for the service and well-being of the citizens of India? Is it the way to preserve, protect, and defend the Constitution and the law? I pray to God, let Epiphany devolve on the President of India, and he starts ruling this country in accordance with the Constitution. The another word misunderstood, misused drastically is the word dissolve. Under Article 83 and 85, this word dissolve of the Lok Sabha is mentioned. Again, under Article 356, the word dissolve is used with regard to the states. Dissolution under Article 356 is time bound, cannot exceed more than 3 years. Of course, through 43rd Amendment, that was reduced to 1 year. So, dissolution of an assembly cannot exceed more than 1 year. If you do not understand that it is a suspension, not dismissal. If it is dismissal, there is no question of time limits. So please understand, dissolution of an assembly under Article 356 is suspension but not dismissal. Whereas with regard to Parliament, the dissolution is only from time to time. We are forgetting to see the first line of Article 85. The President shall from time to time, but not as and when advised by the Prime Minister. There is no provision for dissolution, that means suspension of the Parliament. There will never be a question of dismissing or suspending a Parliament. When an assembly is suspended, its responsibilities are taken over by the Parliament. If the Parliament is suspended, who will take the responsibility? As such, dissolve means suspension, not dismissal. It is not meant for conducting midterm elections. These are some of the words misunderstood, misused, misapplied, either innocently or malevolently. I do not know. But these misunderstandings destroyed India. Had there been an Indian language, these provisions could have been understood even by 10th class student. Thank you. Thank you for watching my video. I request you to please subscribe, share and comment on my videos, and I will be glad to reply to your worthy comments. We will come up with discussion on legal luminaries who also misunderstood the provisions of the Constitution. In the next video, I will be discussing about the greatest ever advocate, Naniya Palkiwala. Thank you.